Welcome to the Deep Dive, your essential shortcut for getting grips with complex information. Today, we're immersing ourselves in a really crucial piece of legislation. It fundamentally reshaped how truth is, well, how it's ascertained in South African courtrooms. The Law of Evidence Amendment Act 45 of 1988. We'll call it the LOEA Act.
It really is foundational.
Uh,
We often focus on the big constitutional cases or procedural law, but this act, it set the actual rules of engagement for evidence
you got
itself.
some nuts and bolts.
Exactly. It was assented to back on April 15th, 1988, and it properly kicked in, changing everything, on October 3rd of that year.
And just a quick note for those tracking the, let's say, the administrative side of things, even now, this act is still relevant bureaucratically.
Oh, really?
Yeah, as recently as October 11, 2024, the oversight, the powers and functions were officially transferred to the Minister of Justice and Constitutional Development.
Right, which just underlines its ongoing importance, doesn't it? It's still very much a live piece of the legal machinery.
Yeah.
And if you look at the preamble, the act itself tells you what it set out to do.
Yeah.
It lists 4 critical areas it wanted to transform.
Okay, what were they?
Well, firstly, it aimed to integrate non-statutory law, making it easier for courts to recognize or take judicial notice of both foreign law and indigenous law.
Right.
Secondly, it created a whole new framework for admitting hearsay evidence, which was a massive shift.
Huge. We'll definitely get into that.
And thirdly and fourthly, it tackled the rules around married couples testifying, amending both the Civil and Criminal Procedure Acts regarding spousal communications and whether a spouse can be forced to testify.
Okay, let's jump into that first big shift then. Judicial notice of law. That's Section 1 of the Act. For someone maybe not steeped in legal jargon, what does judicial notice actually mean?
Good question. Judicial notice is basically when a court accepts a certain fact as true without needing formal proof laid out before it. It's a shortcut for established facts.
So, like, the court knows the sun rises in the east, no need to call an astronomer.
Precisely. And before this 1988 Act, foreign law or indigenous law wasn't treated like that. It was treated as a fact that you had to prove.
With expert witnesses and piles of documents.
Often, yes. It could be complex, time-consuming. Section 1 changed that. It allows any court to take judicial notice of foreign law or indigenous law, provided, and this is the key bit, it can be ascertained readily and with sufficient certainty.
Okay, so if the point of Zulu customary law is clear and easily looked up, the judge can just apply it.
In essence, yes. Assuming it meets that readily ascertainable test, it streamlined things considerably. But the indigenous law part has, well, some very specific nuances.
Go on.
The Act defined indigenous law maybe a bit archaically now, but at the time as the law or custom as applied by the black tribes in the Republic. And right away it put in kind of safety valve.
Which was?
That indigenous law must not be opposed to the principles of public policy or natural justice.
So a sort of repugnancy clause, allowing courts to strike down customary rules that clash with broader fairness standards.
Sort of, yes. But then, almost immediately, the Act creates this major, really significant exception to that rule.
Okay, this sounds important.
It is. It's a fascinating balancing act. There's a specific proviso. It explicitly states that it shall not be lawful for any court to declare that the custom of lobola or bogadi or other similar custom is repugnant to such principles.
Wow. Okay. So the Act says integrate customary law, check it for basic fairness, unless that check challenges core cultural practices like lobola or bogadi, the bride wealth customs.
Exactly. It carves out protection for these central cultural institutions.
Doesn't that seem potentially contradictory? Protecting something even if it might clash with natural justice.
It certainly raises deep questions about legal pluralism and where the limits of judicial review should lie when dealing with deeply embedded cultural norms. The legislature made a deliberate choice there.
A choice to prioritize cultural preservation in that specific instance over a uniform application of public policy.
You could put it that way. It recognized that some practices are just too central to be dismantled by applying common law-derived fairness standards.
And quickly, what if you have a dispute between people from different tribes? Whose customary law wins?
The Act thought of that. If the parties haven't agreed otherwise, the court defaults to the indigenous law of the place where the defendant or respondent in civil cases lives or works.
Simple enough.
And if there happen to be 2 systems operating in that area, it defaults to the law of the defendant's tribe. It's a practical rule to avoid getting bogged down.
Okay, let's shift gears to Section 3. For many people, maybe watching legal dramas, this is the big one. Hearsay evidence. what exactly is hearsay?
Right. Hearsay is any evidence where its value, its truthfulness, depends on the credibility of someone who isn't actually in court testifying.
So witness A is on the stand saying, Bob told me he saw the defendant do it.
Exactly. The crucial bit isn't what witness A saw, but what Bob supposedly saw and said. Bob isn't there to be cross-examined, to have his eyesight, his memory, his motives questioned.
So the traditional objection is reliability. You can't test the source.
Precisely. And historically, the rule was pretty much a strict ban. Hearsay was inadmissible, full stop, with very few rigid exceptions.
But the 1988 Act changed that dramatically. It kept the general ban, but opened up pathways for admission.
It did. It moved from that rigid rule to a much more flexible system based on judicial discretion. Section 3 says hearsay is not admissible unless one of three conditions is met.
Okay, what are the three doors to admissibility?
Door number 1 is simple: agreement. If all the parties involved, especially the one the evidence is used against, agree to let it in, then it's in.
Makes sense. Door number 2.
Testimony. If the original person, Bob, in your example, the one whose credibility matters, actually comes and testifies later in the same proceedings, the hearsay can be admitted, sometimes even provisionally if the court expects them to testify later.
Right, because then they can be cross-examined eventually.
Exactly. But door number 3 is the game changer. It's the interests of justice test.
This is the one that gives the court real power, real flexibility.
Absolutely. The court can admit hearsay, even if the parties don't agree and the original speaker isn't testifying, if the court believes it's in the interests of justice to do so. But it's not a free-for-all.
No. How does the court decide?
The Act lists 7 specific factors the court must consider. We don't need to tick them off like a shopping list, but they boil down to, I think, 3 core questions the judge has to ask.
Okay, what are those core ideas?
First, necessity and reliability. Is this hearsay evidence actually needed? Why can't we get the evidence from the original source? And how reliable does this hearsay seem? Anyway, what's its probative value?
Right. Is it crucial? And does it seem trustworthy?
Second, context. What kind of case are we dealing with, civil or criminal? What's the specific purpose for offering this hearsay evidence? Is it central to the case or a minor point?
Okay, context matters. And the third pillar?
Fairness. Crucially, what's the potential prejudice to the party if this untested evidence comes in? Can they effectively counter it? And are there any other factors, anything unique to this situation, that push towards letting it in or keeping it out?
That's a much clearer way to think about it than just a list. Necessity, reliability, context, fairness. The court weighs all that up.
Precisely. It's a balancing act. The act essentially recognizes that sometimes the only evidence you have is hearsay, and rigidly excluding it could actually lead to injustice.
So it empowers the judge to say, look, this is technically hearsay, but it's vital. It seems pretty solid. The original person genuinely can't be here, and it wouldn't be unduly unfair to let it in, so we will.
That's the essence of it.
Yeah.
It moves South African evidence law into a more pragmatic, modern space, demanding careful judicial discretion rather than just applying a blunt rule.
Okay, fascinating stuff. Let's move to our final section. Family matters in court. Spousal privilege, witness competency. This involved changes to both the Criminal Procedure Act and the Civil Proceedings Evidence Act. Let's start with competence versus compellability in criminal cases. What's the key difference?
It's a crucial distinction. Competence simply means a person is allowed to give evidence. They can testify if they choose to.
Okay.
Compellability means the court can force them to testify. If they refuse, they could face consequences, like contempt of court.
Got it. So how did the 1988 Act change this for spouses?
The big shift in Section 195 of the Criminal Procedure Act was this. The wife or husband of an accused person is now competent to give evidence for the prosecution.
So they can testify against their spouse.
But not compellable. Generally speaking, the prosecution cannot force one spouse to testify against the other.
That preserves the marital relationship to some extent, protects that bond.
That's the underlying principle, yes. They can choose to help the prosecution, but they can't usually be forced into that position.
But,
And it's a big but.
there are exceptions.
Significant ones. That protection, that non-compellability, disappears if the crime itself involves harm within the family unit.
So the law prioritizes protecting individuals within the family over the abstract sanctity of the marriage in those cases.
Exactly. The spouse becomes compellable, meaning they must testify if called when the accused is charged with certain offenses.
Such as?
Things like offenses committed against a person of either spouse or against a child of either of them. So assault, abuse,
Right.
offenses under specific child protection laws, like the Child Care Act, concerning their children, non-payment of maintenance under the Maintenance Act.
Makes sense.
Also, crimes that undermine the marriage itself, like bigamy or incest, and abduction, even perjury if one spouse lied in court proceedings involving the other.
So basically, if the charge involves hurting your spouse, your kids, failing your family duties, or undermining the marriage vows in specific ways, the protection drops. Your spouse has to testify if the prosecution calls them.
That's the gist of it. It strikes a balance between protecting the marriage and ensuring accountability for intrafamilial harm.
And there was a small clarification about co-accused, too.
Yes. Section 7 just tidied up Section 196 of the CPA, confirming that if you're on trial with someone else, your spouse cannot be compelled to testify for your co-accused's defense.
Okay. But perhaps the most enduring change relates to what spouses say to each other during the marriage, the communication privilege.
Absolutely. This is covered by Section 4 for civil cases and Section 8 for criminal cases, amending the respective procedure acts. It deals with marital communication privilege.
What's the core principle there?
The principle is that communications made between spouses during their marriage are privileged, meaning they generally cannot be disclosed in court without the consent of the spouse who made the communication.
And the key change the 1988 Act made.
The crucial amendment was making it explicit that this protection continues to apply even after the marriage has ended, whether through divorce or annulment.
That's huge. So things you said to your husband or wife in confidence during the marriage remain protected forever, even if you later split up acrimoniously.
Precisely. Your ex-spouse cannot be forced years later to reveal those private marital communications in court against you.
Why is that protection so absolute, even after the relationship is over?
The idea is to foster complete trust and candor within the marriage itself. Couples should feel secure that their private discussions won't ever become courtroom fodder, regardless of what the future holds for their relationship. It preserves the integrity of communications made while the marriage existed.
Okay, this has been a really clear walkthrough. Let's try and summarize the big picture from the 1988 LOEA Act.
Sure.
It seems like the Act really pushed South African evidence law towards, well, flexibility and integrating different realities. We saw those three major shifts. First, formalizing how courts deal with Indigenous and foreign law, making it easier to apply, but also carving out that specific protection for cultural practices like lobola.
Right, acknowledging legal pluralism.
Second, revolutionizing hearsay. Moving away from a strict ban to that flexible interest of justice test, giving judges discretion to admit necessary evidence.
A major move towards pragmatism.
And third, clarifying the roles of spouses in court, making them competent but generally not compellable witnesses against each other, unless family harm is involved, and cementing that lifelong privilege for marital communications.
It really was a significant piece of legislation, knitting together customary law considerations with modern evidence principles and giving courts the tools and the discretion to navigate complex situations.
Which leads us perfectly to our final thought for you, the listener, to mull over, drawing directly from these complexities we've discussed.
Go on.
The Act gives judges this really delicate task, doesn't it? On one hand, they need to assess Indigenous law against potentially broad, maybe even subjective standards like public policy and natural justice.
Yes, a significant gatekeeping role.
But then, in the same breath, the Act explicitly forbids them from applying those very standards to something as central as lobola.
He does. The tension is right there in the text.
So the question for you to consider is, how challenging is it for a court to perform that balancing act? To respect cultural autonomy, especially when explicitly mandated for certain practices, while still fulfilling his duty to ensure fairness, according to broader legal principles.
And perhaps, how does a judge even define natural justice or public policy when faced with legal concepts rooted in entirely different cultural or philosophical frameworks? That inherent tension, that need to navigate potentially conflicting values, it remains a live issue, something to think about.
Indeed. On that note, thank you for joining us for this deep dive into the Law of Evidence Amendment Act 45 of 1988.
A pleasure.
We'll see you next time.